That was fast. We're going to need a name. Is it Lawsuit Mageddon, Lawsuit Apocalypse, Lawsuit Avalanche, Lawsuit NATO? Like a shark NATO? Maybe. Tati Westbrook's lawyers have filed a motion in federal court in Washington regarding the destruction of evidence. You know we have to talk about it. So let's just get into it. If you're new here, and so many of you are, I'm so glad to have you here. I'm Emily D. Baker. I'm the badass lawyer, host of the Get Legit Law and Shit podcast. I'm a legal commentator. I've been a practicing attorney for over 15 years, 10 of them as a district attorney. And we break down the stories you want to talk about from the legal side with facts, not. But we'll get into that later. I'm going to just go ahead and pull this up and we're going to talk about it. Do you see, like, I can't believe this happened. When I saw this go down on Twitter, I just about fell out of my chair. I have to say, though, if you're new here, I do have a text community. You're welcome to join the text community, totally free, just texting between us. It is actually me. Or you can join the channel down below. There's a membership. You get early access to shit like this. I forgot to warn you. I say the cursey words. So headphones are a good call because your girl drops some F-bombs. Just saying. Oh, y'all. This, like, I'm not speechless. I'm surprised. There are some basic things in lawsuits, and I spent a lot of time in court. That's what I did as a district attorney. There are some basics. Let's talk about what we learned from this. I'm going to break it down. I'm sure you've seen this on Twitter. If you haven't already, it's on Twitter. Go check it out. You can read it for yourself. I find it helps to have a law degree when we talk about these things. So this is in the defamation suit. I have two other videos regarding the Tati Westbrook lawsuits. There was a lawsuit filed in Los Angeles where a business partner is making allegations. There was a lawsuit that Tati, her husband, and Halo Beauty filed in the state of Washington against Katie Joy Paulson and Without a Crystal Ball, a drama channel here on YouTube. Again, these are all allegations. Nothing has gone to court yet. There are some facts in this because there are attached declarations that have, evidence in them. So we're going to talk about that. But these are allegations in the case. It hasn't gone to court yet, not even for the first time. There were some very interesting things in how these two cases are playing together. I didn't think this would start snowballing this fast, but I should have known when I watched stuff happen on Twitter. And you've got Tati's lawyer on Twitter and seeming fans of Without a Crystal Ball up on his Twitter being like, are you even a lawyer? Guess what? We're going to answer that question right about now. We're not going to get copyright striked, and you're not going to have to listen to me sing. Declaration of Michael J. Saltz in support of the plaintiff's motion for an order to preserve evidence. What's an order to preserve evidence? It's an order to not delete your shit off the internet when you're in the middle of a defamation lawsuit. In layman's terms. I'm going to go through the declaration first because it has the attached exhibits, but we're also going to go through the motion for an order to preserve evidence. That means that Tati Westbrook, Tati James, and Halo Beauty, the plaintiffs, are saying to a court, you need to tell them to not remove or delete evidence. Do y'all remember when this first went down and Katie went on the internet? Was it a live stream? Was it an Instagram? I know you'll tell me, where she said, my lawyer said, I'm not removing anything. I'm not removing anything. Something to that nature. It was, or my lawyer said I didn't have to remove anything. I'm not removing anything. It was something like that she said in one of her streams where she was like, I'm not removing anything. Well. So this is an order for don't delete your shit. Let's move on. This is going to be heard in court on December 18th. It'll be nice in Seattle. It'll be chilly. Doesn't really snow in Seattle, but You might get some rain. I would definitely bring a coat to Seattle for this December 18th hearing. Michael J. Saltz, as we know, and if you follow him on Twitter, you will know. If you don't follow him on Twitter, as this pops off, you might want to. I am, just because I want to see what happens, right? He's an attorney admitted pro hoc vice, which just means I'm licensed in California. I've been admitted to the court in Washington because I am part of an entertainment firm, and California is where we're located, but this suit is in Washington. So I've been admitted with the other, there's two firms involved here, but admitted to practice in Washington because this is in Washington federal court. So this is his declaration. So the attorney is saying, I, as an officer of the court in this sworn affidavit, these are facts. So these are facts. Within a half an hour of the complaint being filed on Friday, October 30th, I sent a copy of the complaint and a preservation of evidence notice to defendant Katie Joy Paulson via email. The preservation of evidence notice expressly instructed, not unusual by the way, defendants to preserve published content related to my clients, including, without limitation, social media posts, comments on social media posts and videos, live chats, direct messages, instant messages, emails, phone messages, text messages. Any further notice requested, the notice further requested that defendants preserve as evidence any content related to or regarding my clients in any way that you posted to or published on any internet platform, including but not limited to Instagram, Twitter, YouTube. Finally, they said, the failure to do so may result in an evidentiary or other sanctions being imposed against them being the person who removed it, in this case, the defendants. Evidentiary sanctions aren't good, but other sanctions are also not good. Sanctions mean you did shit you shouldn't have done and you are going to get fined and or reprimanded in some way. Like when you think of being called to the principal's office in front of a judge, it's like a million times worse than that. Mhm. Angry judges are no fun. I'm just speaking from personal experience as somebody who's litigated trials in a courtroom. This kind, this kind of stuff. Oh yeah, my notes. Didn't she say she was not taking it down? So you'll see the exhibits for me. I did them in blue. I am going to read some of this to you guys, but not the whole thing, so I can interject my commentary. But it's interesting to know that on 7:23 a.m., Saturday, October 21st, Tati's lawyer received an email from Without a Crystal Ball's lawyer in Minnesota referring to the lawsuit, saying all further communications be directed to him. That's totally standard. Hey, I'm this person's lawyer. Talk to me. And it's attached. We get to see the emails. Exhibits are so much fun. I was actually disappointed in the partner lawsuit. And if you watch that video, I think I say in there a couple times, like, nothing's attached. I really wish we had the attached documents with the corporate formation documents. I was like, y'all, if you haven't figured out that I'm a nosy bitch when it comes to this stuff, if you're going to file it in court, I want to see. I loved tracking stuff down as a DA. I like seeing all the evidence. So if I'm not going to go finding it in places where you shouldn't, but I love seeing it attached to documents like this because I'm curious. I know what could be there because I've done cases like this. So I know what kind of stuff you're going to have. And I'm like, I want to see the things. So we've got exhibits on this one, which is tea. These exhibits are so good. Okay. So defendants, after receiving the evidence preservation notice, the don't delete shit, began deleting their videos and other online content related to my clients, including content referenced in the complaint. There are 40 videos referenced specifically in the complaint. It's in the video. There's a list of them. I'm just gonna pull it. There's, in case we've all forgotten, there's a lot of specific videos listed. There's a list of 40. There's a list of 40 videos. Videos listed and referenced specifically in the complaint were deleted. Oh, that is that's not going to go well. from various online platforms such as YouTube, Facebook, Twitter. Exhibit C. I love exhibits. Attached as Exhibit C, exhibits are examples and evidence of defendants' deletions that I personally acquired between October 30th and the date of the execution of this declaration, November 4th. So when people are like, lawyers are on social media, yes, because of stuff like this. And because somebody has to say, this is what was going down. I know it was going down because I was looking for this stuff and now it's gone. These mass deletions began immediately after I set the preservation of evidence notice and complaint to defendant on October 30th. The conduct has continued to date. In fact, my office was in the process of documenting tweets on Defendant Without a Crystal Ball's Twitter page and witnessed the disappearance of tweets related to my clients. Can you imagine being the attorney standing in court going, yes, Your Honor, I received the preservation of evidence notice. Yes, I advise my clients, because that's what you do when you get the thing. You advise your clients of what they say. Yes, I advise my clients. Did you see the tweets go missing? Ooh, that's going to be an interesting thing to explain to the judge, because all of you all on social saw this happen too, because I watched you call it out, because I was like, oh, I thought she said she wasn't deleting anything. I saw all the comments on Twitter. Anyway, so did Tati's lawyers. In addition to actually witnessing some of the deletions, we also observed tweets by others calling attention to defendants' sudden deletions of content on their various social media platforms. Then at some point over Halloween weekend, Defendant Without a Crystal Ball's entire Twitter account was deactivated. We all remember that. It was right after Keemstar was like, I can't support this shit. We saw that happen. On November 2nd, 2020, the Twitter account had been reactivated but had 37 less tweets. Twitter says how many tweets are on the Twitter. It makes it easy. Similarly, by November 2nd, Defendant Paulson had deleted every tweet prior to September 13th, 2019 on her personal Twitter account. And then this goes into the fact that on Twitter, on Facebook, on YouTube, when things are deleted, you lose all the analytics of them, and the analytics can be important in a defamation suit. And we'll get into more of that, but it just goes into the fact that once stuff is deleted, yeah, we might have screenshots of it. Some of you might have screenshots of it. The attorneys probably have screenshots of it. One can assume, because they said they were preserving it, but you don't have the back end analytics. You can't get that until you go through the discovery process. And that shows things like how many people viewed it, if it was retweeted, shared, and it's a defamation suit. Publishing the thing is part of a defamation suit. So evidence of publishing has to be preserved. We saw it going down and I was like, ooh, but I honestly didn't even consider the analytics back end part of it until I read this and I was like, oh, I wasn't, look, it's been an election week. My brain was not fully in my head and I was like, I completely didn't even think about the analytics part of this because it is a huge part of what you need. And I'm used to dealing in criminal where we get different types of things and we're proving different types of things. But proving the analytics in a case like this does become important. Okay, look. The attorney tells us why he knows Twitter and that he was on his personal Twitter account. That he has a Twitter account. It's in here. And that they were going through and the law firm was documenting it at the time. But he also talks about YouTube. Don't we love talking about YouTube? I have personal experience with the way YouTube channels work. My personal experience derives from the fact that I currently represent multiple YouTube channels, including a YouTube channel that in 2019 was the largest and most successful YouTube content provider in the world. I want to know. Highest paid YouTubers of 2019. Ryan's Toy Review. Y'all, is that tea? Like, is that? Was the largest and most successful YouTube content provider in the world in 2019. I mean, I feel like we're talking about Ryan. I just curiosity. Because in my mind, I'm like, but does PewDiePie live in the States? Like, does PewDiePie have an LA? Not PewDiePie. Sorry, PewDiePie. Not PewDiePie. So, so without a crystal ball is fucking with Ryan's toy reviews lawyer. I just can't. I just look. If we didn't know that this firm was used to representing celebrities in the celebrity sphere, we are now well aware that they deal with YouTubers in the YouTube stratosphere. Oh my. I don't have words. But wouldn't you love to see those analytics? Like, wouldn't you? I mean, wouldn't you? The largest and most successful YouTube content provider in the world, and my representation involves issues with regard to the management of the analytics related to my clients' pages. I also have personal experience in managing the technical aspects of a YouTube page. It would be fun to see those analytics. I'm just saying, we're gonna move on. You guys don't even know. I have an 8-year-old. I hear so much about Ryan's Toy Review. My 8-year-old still adores Ryan's Toy Review. We have Ryan's Toy Review like surprise eggs and all this stuff. And I'm a little like, your girl gets discombobulated and a little bit shook. I'm like, and my kid tomorrow, when I'm like, no, but the lawyer involved in this also represents Ryan's Toy Review, my kid actually might be interested in what I'm making videos about. But anyway, this next part gets into describing for the judge and explaining that you can make videos public or private and delete them, that you can have different types of analytics and why the analytics are important. And we'll get into that in the next part of this. But I want to get on to the evidence because there's evidence attached. I also have a personal Twitter page. I talked about this live. And if you guys don't join me live, you should. We have fun. And if you're a channel member, you get the little badges. I'm drawing custom ones. I'm so excited. But anyway, I also have a personal Twitter page. Did you see Tati's lawyer getting trolled about not being a real lawyer on Twitter? I think I retweeted it, but it's on his Twitter page. And she's like, whatever, pretending you're an attorney is a crime. And I'm like, oh God, this isn't, you don't troll the lawyers. In the same way that if you have been sent cease and desist, which Without a Crystal Ball has said she was sent for cease and desist, and the clip that is going around, Dustin Daly shared it. I know Nick Schneider shared it. But in the clip that's going around of her saying, they've sent me for cease and desist, they're never going to sue me, they don't want to sue me, it's been 18 months, don't tempt the fleets of lawyers, because there's a lawyer sitting there seeing that being said going, I'm ready. Because if this was my client and I saw that video, that would have been me. I would have been like, can we do this now? Can we do this now, please? I'm ready to do the things. The problem with being a lawyer is it's your client's decision. So you don't always get to do what you want to do. But I can imagine working in this field that video would have struck a little bit of a chord with me, but I can't say if it struck a chord with Tati's lawyer or not, but here we are. This probably did. This was probably like, I can't believe this is happening, because it's something that happens in cases, but for the attorney that has to explain all of this Without a Crystal Ball, the conversation is going to be like, yes, but this is how this is going to play out in court. I've never had a client do this to me, and I would not take it kindly. I would be, because I'm the one who has to stand in front of the judge and try to explain this shit. The client sits there or be like, you represent yourself. I'm teasing, but I'd feel that way. So we know the lawyer has a personal Twitter page. I love that. I have a personal Twitter page. Yes. Oh, why? I am familiar with the workings of Twitter as a result of my managing the same, as a result of litigating cases involving Twitter and efforts to retrieve deleted information in other litigation matters. So then getting on to the analytics, what the analytics look like. Once a post or tweet's deleted, the analytics are gone. Same thing was said about YouTube and Facebook. And from our own personal experiences, we generally know that's true. Let's get into the exhibits. I added the color. Look, lawyers don't get to add fun color when they file things in federal court. Federal judges are not about this. This is me highlighting so I can visually see it when I scroll to talk to y'all. This is from the attorney. I know these are public records. The DA and me can't put emails out there. It doesn't sit right. This is the email from October 30th saying, good afternoon, good evening, 10:40 p.m. Good evening, you've been sued. And this has the case number, all the things we expect. Our office represents Tati Westbrook. Attached, please find the lawsuit filed against you individually and without a crystal ball. So this was sent to, this email would stress me out if I was an individual, because it's like, hi, you've been sued for defamation. Well, welcome to the party of being sued. By way of this correspondence, you're hereby on notice, and it is hereby demanded that you preserve all documents and evidence relating in any way to any content that you have published on any platform related to our clients, including social media, comments on social media, videos, live chats, direct messages, and all the things are listed. This is very common in any kind of civil suit where there's any kind of documentary evidence like this. Any and all communications with Pathos, any other correspondence. We further request that you preserve as evidence any content related to or regarding our clients in any way that you posted or published to any internet platform, including but not limited to Instagram, Twitter, YouTube, and that you notify any business partners or other individuals involved with the dissemination of false information regarding our clients of this notice and obligation to preserve emails. So anyone that they're communicating with, it really feels like as we get into this with the way that the does were pled, and it's an hour long, the other video, but the way that the does were pled and the way that the Pathos article lines up in the things it talks about so closely with the business partners lawsuit, it feels like there is communication here that we don't have the full story around, and somebody is giving that information to Katie Joy. It feels like there's something around that, and there's some info. I don't know what it is. It's that the language matches up so clearly, and that when the Hawaii lawsuit stuff started to come out, it was like, how did you find that? I know we talked about this in the chat on one of the lives, and I'm like, I've looked for stuff, but how do you know to how do you know to look in Hawaii? It's just, unless, I mean, maybe she searched all 50 states. It's totally possible. In every district of all of those 50 states, it's to come across something. It's totally possible. But it just, there's something that's too connected between those two suits for me to not think that there's connections. And then we further request that you notify any business partners or other individuals if, I don't know. It feels like we've got a working theory going that there's some more information there. And I would love to know in the comments what you guys think that is, who you guys think that is. Like what there's sometimes when things are too coincidental, it's because they're not coincidental. And it feels the language in those suits, I've said it since we saw that defamation suit, it's too coincidental for me. During the course of federal litigation, your failure to comply with this demand for preservation of documents and evidence may result in evidentiary and other sanctions being imposed. Money damages, jury instructions, other stuff. So that is the email that went with the attached lawsuit to Without a Crystal Ball. Then this is the email from her attorney, Aaron Hall, saying, we represent her and her business affairs. Please direct any communications towards us. And then can we just schedule a call and touch base? Not uncommon, but Saturday, October 31st, they've acknowledged, though it's different than service, they've acknowledged initial receipt. So they're aware of it. Service becomes a different, more technical thing, but we know that they're aware of it. So they have information, and they have the information about the preservation of evidence request that just attaches. So, Exhibit C, screenshots of YouTube with the deleted videos that are missing. The privated ones at least aren't gone, but the deleted ones are going to be really problematic, because even though the video itself may be preserved, and I'm going to suppose that it is, because normally those things would be screen recorded and grabbed, but you lose all of that analytics. And I can't believe I didn't think of it. Honestly, I was like, oh, these are going to be screen grabbed and recorded and stuff. But there's so much information in the back end. It's been an election week, y'all. These are Facebook posts. Y'all didn't like this on Twitter either. I saw the Twitter post on this. I commented on one of the Twitter posts on this because it felt mean. So comments being removed is one of the things we're seeing here, because comments can't be removed either per the preservation request. Number of tweets before, number of tweets after. So this gets into like, just, this is the fact that there were tweets, there were not tweets. Oh. These are also tweets. Yet she's deleted 3 streams. A lawyer has trouble defending a lying client. She's screwed, was said on Twitter, without a hairy ball. KJ ain't supposed to be deleting things. And she said she wasn't going to. I remember that. Tell me in the comments if you remember that too. She can't delete this lawsuit away. So not only is KJ on her victim tour, she's on a delete tour, probably due to the pending suit against her, said by Without a Hairy Ball on Twitter. And I love that that's one of the exhibits. But the attorney pointed out, look, other people were talking about these things going missing. But if you're ever involved in a lawsuit, talk to a lawyer when you get things immediately. And it might feel like, oh, I should delete it. Look, don't do that. Once, I say it all the time, you can't put the shit back in the horse, and deleting it's only going to make it worse. It's going to make it worse. It's not going to make it better. Once the shit's out there, there's not much you can do other than defend yourself in court and go through the legal process, because once it's started, it's started. Like, once it's on, it's on. The judges do not like this stuff at all. Federal judges are even crankier than state judges. They are very much more particular. They do not like this stuff. So this is more tweets from Without a Crystal Ball's Twitter thread that are attached as evidence to this lawsuit. A tweet saying this lawsuit accuses James Westbrook of liquidating hundreds of thousands of dollars of Halo Beauty's assets on October 10th, 2020, as the Westbrooks learned about the case, effectively devaluing the company. And then this attaches a screenshot from the case. I talk about that in this week's podcast episode, and I talk about it in the videos. This statement from Without a Crystal Ball and the statement in the business partner suit don't align for me. This is making some statements outside of what exactly is stated in the lawsuit, but it looks like there was a screenshot of the lawsuit there and then comments going after it. So if you want to look at those videos to see those differences, they're there. I remember this. Look, this is from, it looks like this is from Twitter, from Without a Crystal Ball. Lawsuits discovered by Without a Crystal Ball last year, along with criminal convictions for James Westbrook, are referenced in the lawsuit as a pattern of fraudulent and criminal activity. We were tipped off about the suit by a source and asked us to break the story. Well, who knows you're filing the suit? Is it the person who filed the suit? When things are too coincidental, y'all, when things are too coincidental. And then it goes into that the lawsuit accuses James Westbrook of liquidating. We've already talked about that to death. We don't there's only so much because there's more here. So here is the motion the legal motion to preserve evidence. This is asking a judge to do a thing. Like, we need to stop this, order them to stop it, essentially. Going to be heard December 18th. We'll all be here to hear what happens. Hopefully we'll find out what happens. I want to know what happens. Introduction and request for relief. It has come to plaintiff attorney's attention that immediately after this lawsuit was filed, Katie Joy Paulson, without a crystal ball, began deleting videos and other online content, including specific content referenced by the complaint in this case. The statement of facts goes into a lot of the same things that we saw in the attorney's declaration. And then we get into the different social media posts. And this is exactly what was in that email that we saw as the attached exhibit. I love a good footnote. Plaintiffs intend to bring motion for sanctions. So a motion for sanctions, I don't know if everybody will read footnotes. I had law professors that loved footnotes. I always read the footnotes. A motion for sanctions is a motion to fine you in a formal way, generally, because you've done something that is against the rules of how the lawsuit go. So plaintiffs intend to bring a motion for sanctions at a later date to address defendants' intentional destruction of relevant evidence, and such motion, at a minimum, will request a spoliation jury instruction. At a minimum. A spoliation jury instruction means that the jury gets told what they did. So there will be a jury instruction saying, oh, and they destroyed evidence. You know who doesn't like that? Juries. We've got a footnote on cases that this comes from. Willful spoliation. A party's destruction of evidence qualifies as willful spoliation if the party has some notice that the documents were potentially relevant to the litigation before they were destroyed. Federal courts possess the inherent authority to levy sanctions against a party that prejudices its opponent through the destruction or spoliation of relevant evidence. If that feels like strong language, it's because that's really strong language, because the federal courts don't want to fuck with you. Y'all. Oh, it's destruction of evidence is not a good thing. After receiving the evidence preservation notice, defendants began deleting their videos and other online content related to plaintiffs. This feels like the criminal law equivalent of, well, why did you run if you didn't have anything to run from? That's what it feels like to me. Why would you delete stuff if you think what you said is okay? I mean, I guess there could be reasons. I don't know what those are. The mass deletions began immediately after plaintiff's counsel sent the preservation notice. This is what is reiterated in the attorney's declaration, him saying, I know this because I saw this, and here's all the screenshots and evidence proving it. Talking about the Facebook comments, the evidence relied upon here is the declaration of the attorney. And then the issue presented just breaks out for the judge what is happening, what the evidence shows, what the issue is, and what the plaintiff is asking for. And in this, the plaintiff is asking for an order to knock it the fuck off. That's not the legal name for it. You can never go to court and be like, well, Emily said it was an order to knock it the fuck off. No, it's not, but it is. Preservation of evidence. Just so we're all clear. I do amuse myself sometimes. I'm sorry. The argument in authority goes into the case law that supports this and what the court has to find happened to determine if the order will be granted. So if the court is like, hey, these three things line up based on what you've said, I'll issue the order to knock it the fuck off. That's going to be the level of concern the court has for the continuing existence and maintenance of the integrity of the evidence in question. So does the behavior lead the court to go, oh shit, this is probably a problem? 2, any irreparable harm, and that's why we saw all the information about the analytics. Is there shit we can't recover if it's gone? Yes, there's irreparable harm here if the analytics disappear, because you might need the analytics to prove things in the case. 3, the capacity of the individual entity or party to maintain the evidence sought to be preserved. I told you all about the case where somebody stole a yacht and it was a criminal case, and preservation of the evidence became a thing because it was a yacht and the person wanted their yacht back. So we needed to really document the yacht so we could get it back to the individual who the yacht was taken from. But I was like, who's paying to store the yacht? It was a huge, anyway, it was a huge yacht. This makes me giggle. So the ability to preserve it. So if it's super cumbersome or expensive, like a yacht, the court can make other arrangements to be like, this is how we're going to document and preserve the evidence, but we're not going to make them keep a yacht in storage for 5 years. For example, this is all just social media stuff. So then they walk through the different factors of that, which you guys are welcome to read. But look, the level of concern, well, shit's already happened. The irreparable harm, we talked about the analytics and the capacity of them to maintain it. Well, they don't really have to maintain anything because it's social media, like Twitter maintains it. So if Twitter accidentally went down and stuff got deleted, it's a totally different situation than if the individual in their account is going through and deleting it. The attorney points out the significant risk here that it's already been done. In addition, as demonstrated below, the online evidence deleted by defendant is relevant to plaintiff's claims because 1, it shows the content and context of defamatory statements. Remember, the defamatory statements at this point are alleged. They haven't been proven. Those allegations are in the other lawsuit. The reason I don't say like alleged with regard to the Twitter stuff, it's like, well, you can see that the numbers are different. This isn't alleged. This is the numbers are different. But the defamatory statements have not been proven in court. It's just the beginning of this case. So defendants is relevant because of the evidence, content, and context of the alleged statements, shows how defendant's audience perceived the statements. Were they statements of fact rather than opinions? And you're going to see that in things like the comments. Like if the comments are, for example, like, oh shit, girl, that's shady as fuck. What? I didn't know that about Tati or James or Halo. I'm not using those vitamins. I'm not doing that. If there's comments like that, it goes to show how the things were taken versus don't say that, don't say that. That's crazy. So there's context there. That makes total sense to me. IP addresses of other identifying information of potential witnesses and potential additional defendants. Yes, you can't just delete it and make it go away. Shows how many views the statements had, which goes to damages, which it does. The length of time videos were viewed for, which goes to damages. Any YouTubers like, get that watch time. We know exactly how long you watch our videos. Don't think we don't. And y'all are amazing, by the way. Shows how many times and where defendants' defamatory statements were further disseminated by others, your retweets, your shares, things like that. And this explains to the court what that means and that once a video is deleted, it's gone. And YouTube has like 3 warnings, I think, when you're like, yes, I want to permanently delete a video. There's a lot of stuff there. This gets into how Twitter doesn't preserve their analytics, and we saw that in the declaration. Defendant's actions in immediately deleting relevant evidence despite being advised of their duty to preserve such evidence demonstrate a likelihood defendants will continue to delete relevant evidence. It's not a stretch. For the foregoing reasons, if no preservation order is issued, there are significant risks to the continuing existence and maintenance of the integrity. This gets into the irreparable harm, which is the plaintiffs can't get this information without it because it permanently deletes the analytics. Preservation order would not prejudice the defendants and would retain the status quo, which means it's not a huge burden on them and it doesn't make it harder for them to prove their case because once again, the shit's already out of the horse. The deletion of evidence clearly was done in direct response to the commencement of this litigation and not as part of any routine actions on or activities of defendant. Second, there are no physical, spatial, or financial burdens on defendant if they are ordered not to delete additional relevant evidence. Defendants are the only ones with the capacity to maintain the relevant evidence because it's their social accounts. So then it's asking for the order. Y'all. This one. This is not good. This is not good. Destruction of evidence is not looked on lightly by the court. I normally just talk about facts and not my breakdown of them, but when you have all the screenshots, and I know you all saw it on Twitter, what do you guys think? Like, this is kind of one of those, oh, fuck moments. Like, no, you didn't. No, you didn't. No, you didn't. You guys were talking about it on Twitter. I saw the comments where you're like, no, 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 don't. What? But here it is in a motion before the court that's going to be heard on December 18th. When I said that this was going to pop off, I feel like we are at the beginning of the popping off. Like, the first lawsuit was filed and it was like, okay. And then the second lawsuit was filed and I was like, oh shit. And then this, I'm like, here we go. Here we go. We're going to be talking about this the same way people were saying, like, at the beginning of Dramageddon, Aphrodite, Peter Mon are like, we're at the beginning. Rich Lux was saying it too. We're at the beginning. We're at the beginning. I'm saying it now. Mark it down. We're at the beginning. Shit is going to pop off in this case. And I wonder how much the shit popping off in the defamation case will affect the other business partners case, especially if the business partners relying on statements made by Without a Crystal Ball. Let me know what you think in the comments. If you aren't a member of the channel, you want to be a member because then you get stuff like this early. You can always join the text crew. I appreciate you for being here, for supporting the channel, and for wanting to talk about the facts without the fuckery. Thank you so much for being a part of my channel. You guys, this is just... Y'all remember when Kanye leaked all his music recording contracts on Twitter and I was like, oh my God, it's Christmas. I love seeing other people's contracts. We're just at the beginning of the holiday season, friends. I'll see you in the next